Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello folks, we are here today to talk about the 7th Circuit Court affirming Judge Duffins' decision and of overruling Brendan Dassey's conviction and throwing out his confession. So, 7th Circuit Court has now deemed that the state has 90 days to retry Brendan Dassey or get off the pot. Anyways, so, by the way, sorry about the little break for all my subscribers. Sorry about the kind of the little, distance between videos there. Sorry, I had a pretty busy week and it was very hectic and I just didn't have the time. I tried to squeeze it in, but it just didn't work. So, it's Friday night and I'm staying up as late as I have to. So, here we go. Anyways, so some of you may have been seeing some of the reactions out there on Twitter, on Facebook. One in particular is Brad Schimmel that I saw. Brad Schimmel's the Wisconsin Attorney General, and his response I thought was comical, if not just strange. But he basically said he's going to have the 7th Circuit Court review the entirety of the 7th Circuit Court. So what I'm thinking that means, or what I'm understanding that means, is that all of the judges that all are at the 7th Circuit Court will look at the case, I guess, and they will determine whether or not these 3 judges, made the right decision, essentially. So I don't know if that's going to happen or not. I mean, I gotta think that they're getting pretty fed up with Brad Schimmel and his antics. The way that he suddenly filed that emergency motion right before Brendan Dassey was going to get out because the 90 days was up on when the 90 days was up on Judge Duffin's decision, and he goes filing that emergency motion and he's doing all these things, and it's like, why did you wait so long, Brad? Why were you waiting so long to do that? Was it just to let Brendan's followers get a little bit of hope that he was getting out, just so that you could try to dash it? I mean, why didn't you do that in a more timely fashion? I don't know. Anyways, I always just thought that was a little bit strange, but whatever. But he regards this decision by the 7th Circuit Court as erroneous. And my question is this is 2 decisions now, Brad. This is 2 decisions against you. Are they all going to be erroneous in your opinion? I'm sure they will be. But anyways, so we're going to move into the 7th Circuit Court's opinion here, and we're going to see what they have to say about this. And the first part here is where it's at the beginning of the document, essentially, where they're kind of briefly laying out what they intend to talk about. And it talks about Brendan recanting his confession, talks about what's called the totality of circumstance, which is the factor that they use under the AEDPA to basically determine whether or not confessions are voluntary or not. So by using the totality of circumstances, applying it to Brendan, it basically works. It makes his confession involuntary. And what they're going to get to in this document is essentially what they're going to be really focusing on is the fact that the state courts basically ignored the fact that he was a juvenile, and they didn't give due deference to the fact that he was a juvenile. They didn't give due deference to the fact that he was, of limited capacity and highly suggestible. There's really no accounting for that in the state court's decision, and that's what this decision is relying heavily on. And basically saying that it was a wrongful application of established Supreme Court law, because that's what you're limited to with a writ of habeas corpus in federal, in the federal district court, on a writ of habeas corpus. The judge, the magistrate, is very, very restricted in whether or not he can rule a confession involuntary. So we're going to go ahead and move into the documents here. And another thing that this document that I'm about to put up points out is that It basically is saying that it is no longer going to. It basically wants to send a message saying that basically doing things a little bit, where you're essentially leading your suspect down a path of what you want them to say and stuff like that, but because you did it within certain parameters, like you followed the rules, but pushed them, and probably pushed them too far. I think they went outside the rules personally, and it sounds like Judge Campbell and Judge Rovner agree. But the thing is they don't want this to be used. They don't want a state or any prosecuting attorneys or whatever just being able to say, oh, the AEDPA and the totality of circumstance and blah 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 blah, and they're just parroting. They're just parroting is what they say in here, parroting Supreme Court law, and by doing that, they're avoiding any kind of question about how they conducted themselves, because of well-established Supreme Court law, we are technically in the right. Well, I don't think they are technically in the right. How do you feed somebody the information that you want them to say and call it a confession? It's not. It's something totally different. So we'll move into the first document right now. By the time of the trial, Dassey had recounted his confession, and the state had failed to find any physical evidence linking him to the crime. But he was convicted and sentenced to life in prison nonetheless. After appeals and post-conviction proceedings in the state court failed to bring him relief, the state court on post-conviction review stated the generalized standard for evaluating the voluntariness of a confession, totality of circumstances, but failed to note how the juvenile confession requires more care, and failed to apply the standard at all. Dassey filed a petition for a writ of habeas corpus in the district court, claiming that he did not receive effective assistance of counsel due to Len Kaczynski, and that his confession was not voluntarily given. The district court, concluding as we do that the state court did not apply the proper standard, granted the writ, despite the limited role of a federal court on habeas review. We must affirm, if a state can evade all federal review by merely parroting the correct Supreme Court law, then the writ of habeas corpus is meaningless. Well, Schimmel, I think they're on to you, dude. You're in trouble now. Although we report the evolution of this confession linearly, it is far from that. Dassey's story changes. He backtracks. Officers try to pin him down on time frames and details, but they are like waves in the sand. Even the state has trouble telling its version of the timeline of the story in a cogent manner due to the fact that it changed with each retelling. See the brief of the respondent appellate at. Although the state presents a cogent storyline in its brief on appeal, it does so by picking and choosing pieces from various versions of Brendan's story. So, basically, they're taking facts from things that he has now changed, and they're just, from all the various stories, taking the little bits and pieces they need to put together to say the story that they want to tell. You see that bit about parroting Supreme Court law? I swear that was meant for Mr. Berg, because of the way that he kept reminding these judges during the brief. If you guys have seen my other video, I brought this up. I thought it was odd that he was reminding them so much that they might take offense to the fact that he kept reminding them of something that they seemed to already know and believe was a pretty common fact, but he kept saying it. So I honestly think that that's what they're getting at right there with the statement about when they said that if the state or the prosecution can always on appeal just parrot Supreme Court law and avoid any kind of review or looking into the facts of any cases or things like that, that if they can just parrot Supreme Court law and avoid all that, then the writ of habeas corpus is pretty much meaningless. So interesting, but I really think that was in response to Berg and the way that he was reminding them during the oral arguments. So then you move into the next one, where it's talking about the fact that the state draws its story now. It's new timeline. It draws it from like all of the Brendan Dassey confessions, like all the different stories that he told. it draws them. It basically cherry picks whatever little bits it wants out of the several different stories that he told, and just cherry picks the best bits out that they want to be able to tell their narrative, their story, what they are trying to prove. But the thing is that kills me about this is, why not go with the one story that never changed? The one story that he told with absolute consistency. The one where he came home from school and played video games. That's the one story he told that never changed. It was always the same. It's only the ridiculous confession that changes, backtracks, and does all those things. So, anyways, we'll move into the next document now, which is going to be dealing with the actual factors of the totality of circumstance. Basically the template that they're supposed to use in determining whether or not confession is voluntary. So, move into that now. In juveniles, the evaluation of the totality of circumstances includes evaluation of the juvenile's age, experience, education, background, and intelligence, and into whether he has the capacity to understand the warnings given to him, the nature of his Fifth Amendment rights, and the consequences of waiving those rights. At no time did the state appellate court evaluate any of these factors, other than to merely list some of them. It did not provide any analysis of how Dassey's personal characteristics played a role in the interrogation. It did not consider Dassey's suggestibility, did not discuss the fact that he was unrepresented and without a parent's assistance, and it did not consider whether Dassey's low IQ and learning disabilities may have been affected how he affected how he interpreted statements made by interrogators. The court never evaluated Dassey's capacity to understand the warnings given him, the nature of his Fifth Amendment rights, and the consequences of waiving those rights. In short, the state appellate court did not identify the correct test at all and did not apply it correctly. The May 13th interrogation that grew from the poison tree of the O'Kelly interrogation was neither used nor discussed at trial, but the trial court never made any explicit ruling on its admissibility. At oral argument, the state was unable to tell this court why the May 13th interview was not used at trial. But we will assume that based on what the state concedes it was an unacceptable representation by Kaczynski, the state recognized the May 13th interview had been irreparably poisoned. But the May 13th phone call that resulted from that interrogation, the phone call police had urged Dassey to make to his mother on the recorded jail telephone line, was used 3 times at trial. Once to cross-examine Dassey, once to cross-examine Dassey's expert psychologist, and in closing argument to undermine Dassey's alibi. So, the call should be out because it's the fruit of a poison tree. Because okay, so that call that Weig and Fassey, basically bullied Brendan into making. Otherwise, they were going to tell on him, to his mommy. You know how he is. Brendan was suggestible. He's, didn't want his mom mad at him. He, felt like he was, he just felt in between a rock and a hard place. And, he had just confessed again. They just made him confess again. I mean, no doubt the kid's head was all screwed up. But the fact of the matter is that phone call is really the only thing they had on Brendan besides the confession. They just had nothing else. They had no DNA. They had no evidence. No nothing pointing to him. So that's why the fact that the phone call is the fruit of a poisonous tree is, it's good. It throws that out. It throws all these things out. So when Brad Schimmel eventually runs out of things that he can try, runs out of appeals, runs out of making the 7th Circuit Court review itself, and when he runs out of all those things, he's going to be left, he's just going to be left grasping straws. And that's the truth of it. Because they've now taken away everything that they could possibly use to retry Brendan. They've taken away the confession, the coerced confession, and they're taking away this phone call that happened on the prison phone. So there's nothing left to try Brendan with. So it's going to be interesting to see the result of this, if this review even happens, where the Seventh Circuit reviews itself, if that even happens. I'm not even sure it will. I think that they're getting tired of Schimmel. I think that they think he's ridiculous, and they think that he's like playing games. But I could be wrong. But just my feeling, my spidey sense is tingling, telling me that. But anyway, so now we're going to move into the court reviewing what Judge Duffins said and what he felt and his, basically his findings, and they're going to be going over exactly what he, did and how he went about approaching granting the habeas relief in this particular case. So we'll move into that now. Moreover, the district court's grant of the writ was firmly linked to its determination under 2254 D2 that the state court's finding that there was no promises of leniency was against the clear and the convincing weight of the evidence. Concluding that the investigators never made any such promises was no minor error, but rather a fact that was central to the court's voluntariness finding. The district court found that the determination was not merely incorrect, but unreasonable. Secondly, the court concluded that the state court had unreasonably applied clearly established federal law by ignoring the totality of circumstances in assessing the voluntariness of Dassey's confession. The district court noted that although the state appellate court articulated the correct standard, but only as it applied to adults, it ignored several determination factors outright, and most importantly focused on the statements of the investigators in isolation rather than assessing them in view of Dassey's personal characteristics or the cumulative effect on voluntariness of Dassey's confession. In short, a reasonable state court that had carefully reviewed the confession would have quickly determined that the interrogators' pleas for honesty, irrespective of how they intended them, did not have the effect of eliciting honesty from Dassey, but rather had the effect of eliciting guesses from Dassey about what the investigators wanted to hear. In Dassey's mind, the words "be honest" and the like came to mean "guess again until you say what we want to hear." Consequently, the interrogation became not one of eliciting honesty through a voluntary confession, but one of leading Dassey into the story the interrogators wanted to hear. Teresa Halbach's family has now grieved for their painful loss through several trials, multiple state court appeals, state post-conviction relief appeals, and now the habeas proceedings in federal court. If only this court, through its many words, could rewrite the tragic tale of that final day of Teresa's life. But, of course, we cannot. Dassey has successfully demonstrated that the state court decision resulting in a decision that was contrary to or involved an unreasonable application of clearly established federal law, as determined by the Supreme Court of the United States, and that resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. The decision of the district court is affirmed in all the respects, and the writ of habeas corpus is granted. The state of Wisconsin elects to retry Dassey within 90 days of issuance of this court's final mandate, or of the Supreme Court's final mandate. So there we have it, folks. The decision's affirmed. So it comes down to an improper application of federal law, also ineffective assistance of counsel with Lynn Kaczynski. And, the Seventh Circuit Court affirms Magistrate Duffins' decision. Now, I will say that obviously I'm not getting too overboard here with being like overjoyed. I am happy about it. I'm very happy for Brendan, but I'm being a little bit cautious because Brad Schimmel's going to do something. That guy is going to do something. So he's gonna. I hope they appeal it. Honestly, I kind of hope they do. Take it all the way to the Supreme Court, Schimmel. That's great. Let's have new Supreme Court law in the name of Brendan Dassey. That would be perfect. And then finally you won't have anybody else that you can complain or whine to, about this case. So, it's ridiculous. And you want to claim that everybody's decision is erroneous because it doesn't agree with you. That's ridiculous. Anyways. So this decision is affirmed, and I just wanted to show one more thing here, one last little bit from Hamilton. Oh, Mr. Hamilton. I just got to remind this guy that every single bone expert in this case, every single one, all of them, say bones were moved. Now, it just so happens that the prosecution's bone expert thinks that bones were taken out of Stephen Avery's burn pit and put elsewhere. Well, why would that? Why is that? Why would anybody do that? And like I've said this before, if it was an animal would not drag bones into a burn barrel. They might try to drag them out, but they would not try to drag the bones into a burn barrel. So, Leslie Eisenberg, how now, brown cow? How does that work? How does that even, I mean, why would somebody be taking bones from there and putting them in a burn barrel? And if it was an animal, well, it wouldn't have been an animal. So anyways, so it seems to me in this clip you're going to see that Hamilton clearly doesn't know this, or he doesn't care, or he's just, you know, didn't really look into this case as much as he thinks he did. But anyways, so I'm going to go ahead and show that clip here so you can see what I'm talking about. But yeah, I mean, he just because the bones are there, you have to take into account that pretty much every single expert that testified in this case says that the bones moved. Did you know that, Judge Hamilton? I'm wondering if you did. Anyways, that's about it, folks. That's the end of this video. If you haven't already, please hit subscribe, and we'll see you again soon. We also should not lose sight of the most damning physical evidence, the bones of Teresa Halbach, broken and charred, buried in the ashes of Avery's burn pit. The corpus delicti does not point inexorably to Dassey, but it is a grim corroboration of much of the story that he told investigators, which is complete BS. And if you only listen to the bone experts, Hamilton, you might know that.